That's a great question. How did mediation become so closely affiliated with law? So I think part of the answer is a story about, at least in the United States, how mediation became institutionalized. So it's worth remembering that in the 70s and 80s, there was a reasonably robust community mediation movement. And the idea there was that neighborhoods should create dispute resolution centers where people show up with conflict that's mediated entirely by lay volunteers. No court referrals, no police referrals, and this was a sort of radical effort to break from state sort of power, state law, and to articulate a qualitatively different kind of justice that was more community-based, more pluralist. And the story of all the problems that beset the community mediation movement is a really fascinating story. But here, let me just say that at the same time, that vision, that sort of less legalized vision of mediation, was competing with another idea, which was articulated by lawyers and law professors that followed a sort of functionalist kind of thinking, popularized by really important scholars here at Harvard Law School, like Lon Fuller or Frank Sander, who from the very beginning saw mediation as a sort of technique to reform existing legal systems, right? And the idea was not all social problems should be adjudicated, right? Different social problems need different social and legal processes, and for this strand of thinking, mediation was something always internal to the legal system. And that's the kind of vision that became institutionalized and became dominant. And the norms that sort of prevailed were legal ones. And the kinds of expertise that happened were sort of professional legal expertise. And so I think that really gave lawyers a sort of privileged position within the field of mediation. But that all said, I do think that there's interdisciplinarity that remains, right? So any good community mediation center that persists today or family mediation center is going to have social workers or psychologists on their staff. Commercial disputes, when they seek out mediators, will try to find people typically with some industry expertise. So there is some interdisciplinarity, but you're right. Mediation is, I think, as a story of institutionalization, very much within the legal field.
Right.
Yeah, so first, again, I think that's a great framing of the question, because I will often tell my students, think of mediation, as you say, as a field of law, not something alternative to law or outside of law. I do actually think of it as a field of law. As a field of law, it has a sort of general set of conceptual commitments. So rather than, say, neutral, generally applicable rules that can be applied from above, mediative forms of law tend to emphasize individual context, underlying needs and interests, interpersonal emotion, forward-looking rather than backward-looking forms of justice, lay participation, and sort of horizontal participation in an outcome that isn't necessarily winner takes all or nothing, sort of more incomplete kinds of outcomes. And that's a kind of sort of what I call a conflict resolution approach to doing law that's been popularized by mediation, but now I think persists way beyond mediation. So I'll just say, I have a colleague who's named Mickey Alberstein at Bar-Ilan University in Israel, and she has this enormously fascinating empirical project. She and her collaborators have looked at judges in a bunch of contexts in a bunch of countries and tried to identify the ways in which, from within formal adjudication, judges are sort of acting as well in this sort of mediative style. She's coding cases and looking for instances, where judges are drawing on interpersonal emotion or trying to articulate future forms of justice. And it's a really interesting story of how sort of law influenced mediation, and mediation as a field of law influenced sort of law as a field of law. I just don't know if teaching mediation is substantively different, although I appreciate the enthusiasm for the ADR professors you've encountered. So I want my students to learn a set of skills. I want them to understand how these skills reflect a sort of normative and jurisprudential perspective within law, and then to think about how material and cultural hierarchy, race, class, gender can be reproduced, but also challenged through the application of mediation techniques, right? And so I don't think that's actually so different than how I'd approach teaching any substantive law class. But you raise an intriguing question about researching as a sort of scholar of mediation is that different. And I suppose I'd say this isn't unique to mediation, but perhaps different than other strands of sort of doing legal research. You are typically, if you're interested in mediation, you're interested in studying informal practices. Right. And so you can't rely necessarily on doctrine or cases or formal code or text to kind of pull apart for a law review article. You typically need to take a more sociological perspective to sort of see your site of research. Right. And you probably also need to be interested in sort of ordinary problems, the everyday life of the law, not necessarily the sexy Supreme Court cases. Right. And you may also, although not necessarily, you may sort of bring a critical bent to thinking about things like formal legal rights or other promises of liberal legalism, which might be what kind of brought you to sort of researching mediation to begin with. I don't know if there's a best model. I think you're right to say that there's a sort of diversity among the people who both practice a lot and teach a little, or teach a lot and practice a little. When I teach mediation, I always find that the best way to teach it is having my students involved in some clinical practice, right? And so, I want them in a small claims court doing community mediation, so that when we're talking about abstract questions of justice or power, they'll say, yes, today when I was doing a landlord-tenant mediation, or today when I was observing mediation in the Better Business Bureau, here are the pieces I see. So we're sort of constantly trying to bring practice in. But I think one could be a successful practitioner or a successful teacher with a range of sort of balances between the two. Right. Sure. So I think even in the United States, where mediation has been around for quite some time, there's still actually flux. This is how to regulate mediation is still a work in progress. And although there is a sort of federal architecture requiring federal courts to create some, ADR options, a lot of the actual regulation happens at the state level, right? Sort of among the different states. And there's now something called the Uniform Mediation Act that you may have encountered, and that's basically an effort, and many states have adopted it. It's an effort to regulate a sort of minimum floor to promote core mediation values, confidentiality, self-determination, and a sort of minimum level of mediator impartiality. And it's a sophisticated act because it also tries to balance those values against other social values we might want to regulate for. So, for example, we might not want mediation to always invariably be completely confidential. Right? There might be moments where one wants evidence to protect against abuse, or to ensure a criminal defendant has a fair trial, or to even police what happens inside a mediation, like claims for professional misconduct. So this particular act tries to sort of regulate to balance core mediation values against other values, but also to do it in a uniform way among the states. I'll also say, I guess, one or two other sort of, I think, interesting and ongoing things about regulation here. There's also been an effort, and this might be a little bit beyond your question, by sort of self-regulating professional organizations to think about standards or training or credentials for mediators themselves, right? How to ensure a good and regulated mediation practice. And as you might imagine, this is contentious. It's hard to reach consensus because people committed to this field want an enormous amount of creativity and diversity, but also really want to protect the public against unethical practice. So there's an ongoing debate about whether there should be standards to regulate not just mediation, but mediators. And I think the final thing I'll say about regulation in the U.S. Is that we still have, I think, generative and unsettled, really kind of fundamental debates about what to regulate mediation for, right? Which really gets to the core of, what is mediation and what is it designed to do? So should, for example, we think of ways to regulate mediation to make it a cost and time efficient process? Say require early intervention with time caps or fee caps. Should we regulate mediation to ensure a fair process? And what would that look like? The right to an attorney, or support people, or equal speaking time, or skills training? Probably most controversially, should we regulate mediation to ensure fair outcomes? And who gets to decide, and fair outcomes as compared to what? how then to measure these goals is another set of questions. So I think actually sort of thinking about regulatory questions in the U.S. sort of raises really deep questions about why we support mediation and what we think it is, that are still pretty unanswered. Pretty reasonably answered, but still sort of interesting questions that are ongoing. So here's what I told my students the last time I taught mediation. So I think in the U.S., the place to watch now is the criminal justice system. So things like restorative justice or family group conferencing or victim offender mediation have been around in Anglophone countries for a long time, at least since the late 80s or early 90s, but they've never really been all that mainstreamed. And I think here in the United States, we're experiencing a sense of real urgency, a sense of crisis about mass incarceration, about the inequalities and excesses of the criminal justice system, and reformers are looking for alternatives, right? Alternatives to make the criminal justice system more humane, to involve offenders in their communities in repairing social harms and social relationships, not just experiencing punishment, alternatives to bring in more social and cultural context. So I think we're beginning to see this sort of uptake of more mediative ideas by more sort of centrist and mainstream institutions trying to manage the problems of the criminal justice system. Yeah, I think it is. I mean, I think I'll just say, to go back to where I started, what we know from the history of community mediation in the United States is that one should be hard-headed. Alternatives are rarely a panacea, and probably the most radical proponents of restorative justice are going to be disappointed, right, as these sort of ideas reach the center of the American criminal justice system. But I also think they hold some promise to do some reform. So I do think that's interesting to me. I do think that some of the questions raised by mediation in the criminal context are harder and more fundamental. So what does it mean to move away from a neutral, generally applicable rule? You might think that's a really good thing for a dispute between neighbors or a dispute in the context of a family, but a much more freighted thing when it comes to sort of committing a crime. Or what does it mean to move away from the protection of a formal legal system and publicity might seem very benign in an intimate civil context and just more complicated in the criminal one. But at the same time, there are also enormously high upsides to really thinking about what does crime and punishment mean, and what does restoration and the reconciliation of actual human beings mean in the criminal context. So I certainly see why one would think that the stakes are harder and higher and more freighted here. I think they may well be.